Um, just to kind of give everybody a little update on this month we were virtual not because of COVID, but because we couldn't find a venue. The venues are requiring a little bit more commitment on our end as far as the numbers. And pricing is a little bit more. We're trying to keep our events at a reasonable lunch price. So instead of trying to come up with a new venue that we haven't used before, we moved it to virtual. The board did vote on at our last board meeting that in 2022 we're planning to do alternate on even months to be in person and odd months to do virtual. That way we can include people out of the area or working out of the area and bring in some speakers that we might not be able to bring into an in-person event. So next year we're going to alternate, hopefully back and forth between in-person and virtual. I know a lot of people are in a position where their staffing is less and the people that are still working are doing more. So there is a little bit of a convenience in being able to stay at your office and your desk and work while you participate in the virtual events. So we're going to alternate back and forth next year. And then South Point has been great to work with. It gives us plenty enough room that people can be spread out, but they're not always open the second Tuesday of the month. So we're trying to be consistent and keeping in the same venue if possible. So we'll be in person next month at South Point, and we're still looking for a venue for November. We might have to take that virtual, and it looks like our December one will be virtual as well. So just to kind of give everybody an update on that. So at this time, I'm going to go ahead and turn it over to our guest speaker today, Rachel, who you have now control. So if you'd like to introduce yourself and give a little bit of background, that would be great. And if you have questions during, please just go ahead and unmute and chime in, and then turn your mute back off when you're not speaking. Thank you very much.
All right. Thank you, Johnny, so much for the introduction. I'm really happy to be here today. Thank you so much for having me. So a little bit about myself. I'm an employment attorney. I own McElroy Law Firm. We've been in business for 3 years now, and all I do is employment law. So I represent both employees and employers in various lawsuits and in preventing lawsuits. A lot of what I do is risk prevention as much as actually filing lawsuits. So yeah, here's my contact information. I can provide these slides to everyone after the presentation if you'd like them. And I'm happy to answer questions during the presentation. And if you have questions or issues that you're having and you want to contact me after the presentation, feel free to do so. I do offer free initial consultations, and I'm happy to talk to anybody about a particular issue that they're having. All right, so today's agenda is just kind of a quick overview of different employment laws that apply. This is kind of geared a little bit towards managers, but it also applies to employees. I understand a few people here own their own business, or they're independent contractors, or they work in a management capacity. So kind of help you to navigate the laws. Again, I also represent employees, so if you're having an issue with your company, you can also reach out to me. This is not a complete list of employment laws. Employment law in this country is actually pretty complicated. So if you have something that isn't covered, again, feel free to reach out. All right, so laws to consider. I'm not going to go over all of these. These are just different laws that could apply in employment context. So for example, you have your anti-discrimination laws, you have wage laws, you have a whole bunch of other stuff regarding various different interactions, such as benefits and leave and unemployment and workers' comp. So if you have a particular issue and you want to chat about it, let me know. But this is just kind of to give you an overview of what stuff could apply. right. So I always like to start with the beginning, and the beginning of any sort of employment relationship revolves around hiring. And what I tell employers and even employees, it's a good tip for them too, have a written job description. So if you're thinking about adding an employee or hiring somebody new, first come up with what you need in that position and have this written job description. And that's kind of that forms the basis of your relationship. A big thing for me is open communication between employers and employees. I really think that that solves a lot of issues and can help avoid liability and help in a lot of different contexts. And the first communication you really have with somebody is your job ad, which should be based on this job description that you came up with before you decided to hire someone. Now, there's a lot of different laws that apply when you are hiring a new employee, especially the anti-discrimination laws. So my tips for managers and employees when they're hiring someone, and for employees, I would suggest you look for them to have good employment practices. If your employer or future employer has good employment practices and are doing those things, they consider the relationship really important and a place you'd want to work for. So a couple of my suggestions are get the same information for everyone. Make sure that you're not asking different people different questions. Ask interview questions that are just related to the essential functions of the job or what you need in an employee. And that way you're not venturing into kind of these personal questions, which can get a little sticky with the anti-discrimination laws. Don't ask about protected information. We'll kind of go into that a little bit later on in these slides. And what is protected, what is a protected class, what isn't. I mean, some things to think about right now would be like, don't ask if an employee or a potential employee has a disability. That's a really important thing. They can let you know if they are needed for an accommodation, but it's not your job to ask them. Carefully consider pre-employment tests. This actually gets a lot of employers into trouble. I know people are pretty familiar with drug tests, for example, but due to new Pennsylvania law that we'll go over later, actually, testing for medical marijuana can get you in quite a bit of trouble. Consider whether or not you need personality or skills tests. If they're not applied fairly or they have a disproportionate impact on one group of people over another group of people, they can also subject you to liability later on. An interesting fact about Pennsylvania, and this is just a Pennsylvania thing, it's not a federal law, is that you cannot discriminate based on whether or not somebody has a GED or a high school diploma. So if you're an employer hiring someone, make sure you consider both of those certificates as the same. And then finally, I tell people to keep records. It's really important so that if you get audited or the EEOC wants to know something, we'll talk about the EEOC a little bit later, then you can provide them that you have all these good records, done these good employment practices, and can move forward. Speaking of the EEOC, I have a link at the bottom of this slide. So that stands for the Equal Employment Opportunity Commission. They're actually a really great resource for businesses and managers because they publish a lot of information on how to comply with various anti-discrimination laws, and you can check them out for some more information on how to hire somebody without violating the law. Does anybody have any questions? All right, well, we can go on to two Pennsylvania-specific laws that can trip up employers during the hiring process. One of them is the newly passed 2018 medical marijuana law. So as a part of our just got a text from Shannon asking. Getting a little bit of feedback.
Somebody who's called in is on doesn't have their microphone muted.
The hardest thing is
812 number. Let me see who that is real quick.
Our main thing on Ryland's IEP what?
Connie, are you able to mute as like
Unfortunately, I do not have the ability to mute individuals.
Huh.
Trying to figure out who that is.
Okay. Can you just write this down? I gotta start gathering stuff together.
Somebody's on the phone. Can you please mute your microphone?
Okay, I gotta run through the change.
I'm just going to give them a call, see if I can get their attention. Rachel, keep on going.
Okay, sure, no problem. All right, so one thing I want to go back to is this 2018 medical marijuana law. So as a part of the law, the legislator passed it that you cannot discriminate against an employee just because they have a medical marijuana.
And I think the answer.
So this includes in hiring and firing and any sort of employment decisions. And we've recently had cases on this saying that an employee can sue an employer if they were discriminated against for having a medical card. Now, this doesn't mean that you're allowed to be high at work. You can't do that. But just because you take medical marijuana doesn't disqualify you from employment. The other one that is Pennsylvania specific and sometimes trips up employers is the Criminal History Records Information Act. So this is a really long law that's mainly about how to expunge your record if you have a criminal record, but it has one small section that applies to employers, and that is that you can consider criminal convictions in hiring someone, but only as it relates to the job. So, for example, if somebody has a criminal history and it's completely unrelated to the job that they're doing, you can't consider that in denying them employment, or you run afoul of this law. In addition, if you do use somebody's criminal history to deny them employment, you need to make sure that they're notified in writing of that decision. Okay, so here I have a new hire checklist. This is for anybody who's a small employer who maybe doesn't have an HR department, or if you work for a company that does have an HR department, this is kind of the stuff that they should have if you're bringing on a new employee. I'm happy to talk more about this or talk to anybody individually about it if you have any questions, but if you are hiring someone, make sure you do provide these forms. Okay, the next thing I really think is important is an employee handbook. Again, I think this open communication between employer and employees is really important. I know some people don't want to feel like they're micromanaging or they have this huge list of rules, but I don't see an employee handbook as a big list of rules. I see it more as like, here are our expectations. They can help you avoid liability later on in an employment lawsuit, or they can help you avoid paying unemployment to somebody who maybe doesn't qualify for unemployment, which can save the company money. So really, really an important tool. This is a list of some of the stuff that you would want to consider putting in your employee handbook. And for anybody who is a small employer and is doing this on their own, I do recommend that you consult an employment attorney. I do offer employment handbook services and reviews and help drafting. All right, so another thing that trips up employers, and one thing that's really important for employees, is how you get paid. So there are several different laws that govern getting paid. You have the Pennsylvania Minimum Wage Act. So that requires employers to pay at least Pennsylvania minimum wage plus overtime for non-exempt employees. The second one is the WPCL, that's the Wage Payment and Collection Law. And this is actually a really, really important one. So in Pennsylvania, if your employer promises to pay you a certain salary and they don't pay it, you can bring a breach of contract action against them. And the really fascinating thing that kind of trips up a lot of employers is that wages include something called fringe benefits. And fringe benefits can be really anything that you promise to pay your employee. So that could be vacation days, that could be health benefits, that could be short-term disability benefits, bonuses. Now, it doesn't mandate that you have to pay those things, but what it says is that if you did say you were going to pay them and you don't pay them, then the employee has an action against you. A really famous case that's out there right now is Walmart promised their employees that they could get paid breaks. So for example, you get a 15-minute break and Walmart will pay you for it. Well, what Walmart was doing is they were not giving people breaks. They were still paying them, but they weren't getting to take these 15-minute breaks. And so Walmart employees sued and they won under the wage payment and collection law that even though they were getting paid because they didn't get rest time, which is a fringe benefit, they were entitled to additional compensation. So really important for employers to make sure you're paying what you told your employees you would pay them. Two other laws to consider is the Fair Labor Standards Act, which again is another minimum wage and overtime law. If you're concerned about whether or not you're an exempt or non-exempt employee entitled to overtime, I recommend you reach out to myself or another employment attorney, as those categories are really complicated and very job specific, but it does mandate that you pay your employees. And then the EPA is the Equal Pay Act, which says that you can't discriminate against somebody because of their sex and pay them different wages. So this one's actually getting a lot of traction. I'm seeing a lot more Equal Pay Act litigation because, just recent awareness with the different movements, including Me Too movements. My recommendation for employers is to have a range of salaries you pay for a position that's kind of a set, and to not engage in too many negotiations, and to not ask about past salary history. That's actually not a very good practice anymore. Oftentimes women get paid less, so if they start out less, they'll have less going into the negotiation. So you might end up with, Jane, who makes $30,000 at her last job, and you offer her $32,000. Then you have John, who made $50,000 at his last job, and you offer him $52,000. Well, if Jane and John do the same job, you've got a $20,000 wage gap. Sounds like you might be saving money in the short term, but if Jane brings an equal pay action, you'll owe her back wages, damages, additional damages, and attorneys. Actually end up really costing you in the long run. Does anybody have any questions so far? Okay, so if anybody works in the city of Pittsburgh, or if you have employees that work in the city of Pittsburgh, it doesn't mean you have to have an office. It's anybody who works within the city, including people who drive, if you have delivery drivers. You were subject to the Pittsburgh leave. So what that means is you have to offer a paid time off. It varies depending on how many employees you have and other policies. So if you want to learn more, or you can reach out to me. It is something that's unique to Pittsburgh and Philadelphia. It's not a statewide law. So if you're outside city limits, it is not something that you have to worry about. Another leave law that I'm sure many people know about that is a federal law and does apply to all is the Family Medical Leave Act. Now, that's a little bit more complicated. It applies to some employers and not to others, and there's qualifications for employees, so you have to work so many in a year to work for a certain amount of time for an employer to qualify for family medical leave. But those are kind of the two leave acts that you want to be aware of. Okay, so protected classes. I said we would get to this a little bit later. This all involves the anti-discrimination laws. So we have a couple of here in Pennsylvania. We have a state law, which is the Pennsylvania Human Relations Act. We have federal law, which is Title VII, the Americans with Disabilities Act, the Age Discrimination and Employment Act, and the Pregnancy Discrimination Act of 1978. Then, just to make things more fun for employment attorneys, there's also the Pittsburgh City Code, which prohibits discrimination on different protected classes. And there's even an Allegheny County one as well. So I'm not going to go into this too much other than to say, feel free to reach out to me if you feel that this is an issue you're facing right now. If you feel that you have been discriminated against, or you feel like there's a discrimination issue within your company, feel free to contact me. There are different protected classes under each law, different definitions of who is an employer under each law, and some of these laws actually do apply to independent contractors as well. So if you're an independent contractor, you do get some protections under certain laws. Okay, so what is Ask Jan? So if you're a manager or an employer or even an employee and you have an employee with a disability, under state and federal law, you're required to make a reasonable accommodation for a disability. And I always tell employers or employees to go first to the Job Accommodation Network. So this is a government-run website in which they discuss different disabilities and different reasonable accommodations that can be made in a workplace for these disabilities. It's a really, really great resource, and it's free. And if you're an employer or an employee, you can actually give them a call and they can offer you some guidance. So if this is an issue that you're facing right now, you can, again, reach out to me, or this is a really, really good resource. All right, so kind of finally we're moving into the part of the employment relationship no one wants to have to deal with. Employers don't like firing people. Employees definitely don't like being fired. It's always a stressful situation for everyone involved. It is something that I see a lot and work with a lot as an employment attorney to either help guide employers through the process or help an employee who's been illegally terminated. And technically speaking, in the state of Pennsylvania, everyone is an at-will employee. So that means your employer can fire you for any reason at any time, as long as it's not an illegal reason. So one example I give people is that in the state of Pennsylvania, if you walk into work and you have yellow shoes on, and even though nothing in the employment handbook says anything against yellow shoes and nobody's ever told you not to wear yellow shoes, and you walk in and your employer says, man, I really hate yellow shoes, you're fired. That's a perfectly legal reason in the state of Pennsylvania to fire somebody. However, I never, ever recommend anybody do that. That's a good way to get sued. Even if you eventually win the lawsuit, you'll still spend a lot of money on legal fees. So just a bad idea. I do recommend that you have a documented reason that's based on your job qualifications that you wrote up earlier, and you've communicated with your employee what they're doing wrong, why it's a bad fit, why, for example, you don't like yellow shoes. If that's your reason for firing someone, have it in your handbook. Give written warnings, tell them not to do it, and then if they still continue to do it, then you can look at ending the employment relationship, and you'll reduce your liability risk and possibly have to pay less for unemployment compensation. So if you are going to terminate the employment relationship, like we just discussed, have written policies and outlining your expectations. have a progressive discipline policy and use it fairly, so apply it to everybody. Give written performance reviews, let people know how they're doing, have this open communication. If you're really so concerned about it, the EEOC, just like with hiring, has a really, really good checklist for terminating the employment relationship that can really help guide you through the process. Make sure you give everybody the unemployment notices. Unemployment compensation does require you notify the employee about them if you terminate their employment, so make sure you're doing the proper notifications. And make sure you pay all their wages, no matter how poorly it ends, make sure you pay them. There was a recent case somewhere, I think it was somewhere down south, but it was an auto mechanic. The employment relationship really fell down fast, and the employer terminated the mechanic's position and refused to pay him his wages, and he sued, and he won, because no matter what they do, you still have to pay them for time worked. And so to get back at him, they decided to pay him in, I think it was 81,000 pennies for his last day of wages. As long as you're making the appropriate tax withholdings, that's actually a legal way to pay somebody. It just has to be U.S. currency. It doesn't necessarily have to be in dollars or direct deposit. But even if you pay them in 81,000 greasy pennies, you still have to pay them.
Rachel, I had a question for you as far
Sure.
as, so when people given a 2 weeks notice, is that something that if you were in Pennsylvania and I put in my 2 weeks notice and my employer says, well, go ahead and clear out your desk at the end of the day and not worry about the 2 weeks, would they be on the hook to pay that 2 weeks?
No. So if you give 2 weeks notice, and your employer tells you to go ahead and leave that day, they don't. So you only have to pay people for time they actually work for you. Now, it's a much trickier question on whether or not you would be entitled to unemployment for those 2 weeks. That's a little bit trickier question, and perhaps, but no, they can go ahead and tell you don't need to come. And that might be the one exception to having all the written stuff and the warnings and stuff, is if an employee quits and the relationship has really come to a point where it doesn't make sense for them to come back for the 2 weeks. You can go ahead and let them go. So that's a good segue into the next slide, which is all about unemployment compensation. So that's kind of post-termination. The relationship really doesn't end because you still have unemployment compensation, which I like to tell people to think of unemployment as an insurance, because that's really what it is. Everybody pays into it. The employer pays into it. As an employee, you pay part of your wages into it. It is, in that way, it's a little bit more like Social Security. I know it's been in the news a lot recently with the pandemic, and fortunately, it is still, the agency is still pretty overwhelmed and backed up. But you are entitled to apply for unemployment, and unless you get disqualified. There's a couple of ways you can disqualify an employee for unemployment. The two most popular ways employers do that is a willful misconduct. So if your position was terminated by the employer and it's for willful misconduct, then you are not qualified for unemployment. So if we go back to the yellow shoes example, if the employer just walks in one day and fires you for yellow shoes, you're very much likely entitled to unemployment. If the employer has a policy in their handbook that says no yellow shoes, you came in with yellow shoes and they gave you a written warning about it, and then you came in with yellow shoes again and they gave you another written warning about it, and then you came in with yellow shoes a third time and they fired you for it, you are likely not qualified for unemployment. And that is, again, why I tell people to have all these policies in place. Even though it's the same thing, even though it's the same reason you got fired, the first one, you're likely going to get it. The second one, you're probably not going to get unemployment. The other way you get disqualified for unemployment is if you voluntarily quit. So Johnny, going back to your 2 weeks notice, because you said you were going to quit in 2 weeks, yeah, you quit, but the employer terminated you for that 2 week span, which is kind of still an open question on whether or not you can get unemployment. A lot of people don't end up applying at that point, but if you do quit without a compelling reason, are not qualified for unemployment. So various employment laws require employers to post different employment signs. I'm not going to go into all of them. If you're interested in this, you can go to the different websites and take a look at what signs need to be posted in the workplace. One question I've gotten a lot from employers lately is, where do I post my notifications if we're an entirely virtual workforce? So that's a really good question. And what I've been telling people is make sure on your shared drive or your shared folder, you have a folder that's accessible by everybody in the company and clearly labeled notice requirements or employee notices or workplace notices that everybody can access if they want to go look at those different notices. The one I will point out is that if you're in the city of Pittsburgh, they do have a paid sick leave notice that you need to post. And then finally, I have some links to some helpful websites if you're interested in learning more about this, or you have a particular employment issue you want to look into more and investigate further. These are all really good places to go and find the information. And that's pretty much it for me, if anybody has any questions.
Does anybody have any questions for Rachel?
Yeah,
I have a quick question.
Oh, go ahead. Yeah.
Sure. I just, back to the marijuana thing. Did I understand correctly? You said that if somebody has a medical marijuana card and we drug test them, we can't use that as an excuse not to hire somebody like that. We can't have that policy. Is that correct?
Yes. Yeah, that's really tripping up a lot of employers right now, actually. It's becoming very well litigated. If you do a drug test and they don't have a medical card, you can still enforce it because marijuana is still illegal under federal laws. It's if they have a medical card, you have to treat it like you would treat any other prescription. So like, for example, if you have a prescription for certain drugs that would test positive, usually what the drug testing facility does is they mark it as a negative because they have a prescription for it, right? That's the same thing you would want to follow for medical marijuana. And there are cases right now where employers have done just that. They have a policy against marijuana, they did a drug test, they fired somebody, and then they got sued.
So if something were to happen because that person had marijuana in their system or whatever, who's responsible for that?
Yeah, I mean, this is a real question. So the law is very new. And in fact, it was only last year that these lawsuits even really started. Before that, that was still so new, it hadn't happened. So there is an exception for a safety critical position. So for example, if you have a truck driver or who has to follow those sorts of extra safety guidelines, then you can have a prohibition on marijuana. Truck drivers are somebody that are highly regulated and come to mind. They also have different prohibitions on other prescriptions. You have to be really careful on what you classify as safety sensitive, and it's not been well litigated in the courts, so there's not really much guidance.
Wow. Thanks.
Yeah, I have a question, which Rachel is maybe apparent as my wife, but I think this is interesting. She's brought this up to me before, and I think it concerns the Pittsburgh paid sick leave, and it was my understanding, and I want to ask about this because I forget the details, but if you have someone who happens to go into Pittsburgh to do work, even driving through, that somehow this paid sick leave applies to them, but is it is it in the amount of time that they spend in the city they would earn? So if I spend an
Yes.
hour in the city a week, then I would earn 1 hour. I'm supposed to earn 1 hour paid sick leave, even if my company isn't in the city or anything like that.
Yes, allegedly. So the paid sick leave is a really new law. It was passed March of 2020 is when it became effective. So it's still getting kind of sorted. But yeah, I mean, so it's based on how many employees you have and how many hours they work in the city. So it's not a 1-to-1 ratio. You have to work so many hours to get the paid sick leave. But yeah, if you have somebody who's driving around and delivering stuff and they're driving within the city limits, that could is really interesting. Have somebody careful with remote work. It's not really been figured out yet. If you have an employee that lives in, that's something that's still employers are out.
Your mic was cutting out a bit. Johnny, did you hear that, or was that a...
Yeah, it cut out a couple times there.
Oh, I'm sorry. Let me see if I can. Does this work better?
We can hear you now.
Yeah.
Yeah. I was just saying to be cautious of remote work. If you have an employee who lives within the city of Pittsburgh and works remotely, you could be subject to the Pittsburgh Paid Sick Act.
So if you had to go down and pull physical deeds from the Allegheny courthouse, then you would be subject to at least a portion of that, or is it you're good for 8 hours or whatever?
So it depends on how many hours you end up working within the city limits and how many employees the employer has. Now, it applies to all employers, but whether or not it has to be paid versus unpaid depends, and how many hours you have to grant depends on the size of the employer. Now, what I tell people is that if you have a paid vacation policy or you have a paid time off policy already, you can use that. That qualifies under the law. So you don't have to give extra time in addition to what you already offer off. So if you already have PTO, then you're likely that would qualify under the law and you wouldn't be entitled to more time. This is really mainly for employers that give no time off, that have no paid policies.
That's good information to know.
Yeah, and it's a really new law that just again passed last year, so it's one that a lot of people maybe don't know about.
Do we have any other questions for Rachel at this time? Okay. Well, Rachel, if you could do me a favor and send over your presentation, we'll save it as a PDF. We'll send out that with everybody's names who were in attendance today, so everybody can have a copy of it and be able to look at the links and be able to use those. And then, of course, we'll have all your contact information. So if anybody has some follow-up questions, they can reach out to you.
Yeah, happy to do so. And again, thank you so much for having me today.
So just to let everybody know, again, thank you very much, Rachel. We really appreciate it. Our next in-person event will be October 12th. And that will be at the South Point Golf Club in South Point. We're going to have the Association of Professional Pipeliner Surveyors present a topic. So it should be an interesting event. And please, we're looking at planning into next year's topics. So we welcome particular topics or speakers for us to reach out to contact, so we can continue to provide information to everybody in our group that's going to be meaningful and help you advance your career and give you more knowledge. So as we all know, knowledge is and information is a great disposal in your toolbox. So we're always looking to bring in other topics that may be directly related to our industry, or is something like this that just kind of helps you understand if you're going to have employees, what are your responsibilities, or if you're just going to have subcontractors and you have them as an LLC or a C corp or whatever the case may be. So this information I think is very helpful in having an asset and a resource that you can reach out to. It's another important things that we have. That's one thing I learned when I was 18. I worked as an electrician in Northern Virginia, and the mechanic I worked for held up his address book, and he said, "This is going to be the most important tool that you ever have." So having a good contact book of knowing who may know the answers is very valuable in my opinion. So unless we got somebody in the chat here, hold on real quick. Okay, well, that's personally to me, and I'll reach out to that person after. Once again, Rachel, we really appreciate your time today. If anybody has any questions, you can follow up with her after. I'll get everybody the sign-in sheet after Rachel sends over the presentation, and continue to reach out to me with suggestions how we can move the group forward and continue to grow everything. Thank you guys very much.
Thank you, Johnny.